This is instead of that big huge one I gave you.
Sure, can I have one for you?
The work session of February 20th, 2018 will come to order. Our focus is a Charter Review Committee discussion on proposed charter changes. Chair Joe Affronti will present. Mr. Affronti.
Thank you. Before we get started, I'd like for our group that got together to review this charter, please stand and introduce yourself and who appointed you.
Bob Fernandez. I was appointed by Sherry Duncan.
Gil Schilson, appointed by Frank Chilor.
James Chambers, appointed by Councilmember Boss.
And Joe Affronti, appointed by Andy Ross. So thank you. I hope you all got a copy of this prior to tonight. So we'll go over, what I thought we would do is just review each page, because there aren't that many changes, but there are some. So if we go through each page and then any comments you have or suggestions, recommendations or problems, you could bring it up at that point. Excuse me. On page 1, section 201, qualifications, we're recommending the change, and the change would read, the city council shall be composed of an elected mayor and 4 council members elected from the city at large. And then we're also recommending that the number of years required for them to live here before they could run change from 2 years to 1 year. But so what we're recommending is that the mayor, after the 2020 election, will be able to vote. Because in this year, if these recommended changes are approved, then we'll go ahead and it'll be on the ballot for this year. So then it will be it'll be effective after the 2020. Because if they approve it, then it'll be the following election where that change takes place. So that would be 2020, I believe. Is that right?
And Chairman Affronti, did you want questions as each section was happening?
Yeah,
or
I think that
you-
would be the best way, or,
And-
yes, Sherry?
I have a question about the residency requirement.
Okay,
I see that you took out the word immediately and changed it to prior, but shouldn't it be immediately? Because prior could mean 20 years ago,
immediately prior to the
that
date.
somebody comes back and runs for office.
Yeah,
Could you just say immediately prior?
it could. What do you feel, what do you think?
Well, this was, if I may.
Yeah.
We had a lot of discussion on this entire section. And just speaking with the attorney at that point, Mark Conley was advising the commission, and it was a grammatical issue. And the thought was immediately prior and 1 year prior to, if you read the whole sentence, for 1 year prior to the date of the election. And it was felt that the grammatical issue of immediately and prior was identical. So we took the word immediately out, just 1 year prior to the date of election. So the
If I thought that way, you don't think somebody else might think that way too? I mean, why would you not put in just one more word and nail it down?
What's one word? Okay, that's,
Yeah.
yeah,
I-
that's,
it just-
It means the
I-
same,
I-
it's just a
my first
question.
thought.
yeah, I mean, it's,
Yeah,
And my question, I don't know if Mr. Chisler or Chair Affronti, if you're the right ones to pose it to, I had a little pause in looking at reducing our residency from 2 years to 1 year, and I might have been slow on the curve, but I know when I moved to Temple Terrace, it took a period of time for me to really acclimate and understand our culture and understand all the wonderful array of events and organizations and who and what we were as a community. And I thought, prior to wanting to lead this community, either as mayor or council,
that was advice of council.
do you, Do you have any problem with that?
Excuse me, Madam Mayor. That's a statutory requirement. There's been case law that struck down the 2-year requirement. On the advice of counsel, it was 1 year is what's been held up by the courts.
See, I failed to mention that when we went through this, the first priority was to set our charter according to the current laws. And that was our number one priority, make sure that we were legally presented here. And I didn't recall that, but do you agree with that?
I wasn't here at the time that you were going over this section, but I believe that's correct.
Okay. So it's a legal requirement, apparently. Okay.
Councilman
Any
Ross.
other comments?
Yes, I had a comment about this if we're going to do each section at a time. And this is something that did not change, but it's something that I want to ask you and my colleagues if it should. What would happen in a scenario where a person did not reside in the city and filled out the paperwork to qualify to run for office on the premise that they would relocate to the city prior to the election date?
We didn't address
Well, they
that at
wouldn't-
all.
In other words, they couldn't do that, but they could have moved to the city. In other words, what I'm trying to say is, should this be prior to qualifying as opposed to prior to the election date?
We didn't discuss that portion.
Or is that a non-issue?
Again, I think we structured this language based upon the advice from the attorney and that case law. I'm not sure if it is specifically addressed in that case law, whether it's the date of election or the date of qualification.
It's probably
But it
moot
was
because they'd
1
have
year
to
versus
live.
2 years.
Right, they'd have to live in the city when they qualified anyway in order to have been here for a year, so it's fine.
I think what you were saying was that, say you moved into here in November
That's, yeah.
of 2017, you hadn't lived here, or, a shorter time, whatever, but I think we're pretty good on precedent, because I think when we had the earlier discussions with Mr. Conley, the only real issue about the section came up with being the case law and making it the 2 and 1 years.
And I don't know if this is the right place as we look at qualifications, and Chairman Affronti, you might not be the right one to answer, our attorney may be, but as I've been going down rabbit trails over the last couple of months thinking about this, there have been challenges in cities, and in several it's because they haven't specifically stated it in their charters, where it's stated in our state charter, stated in our federal charter. Should there be somewhere in our charter that states, must be a resident of the United States?
Or a citizen?
Yeah, citizen, and yeah, it doesn't matter if they're naturalized or if they have gone through the process, but to be a citizen of the United States.
If I'd have to do some research to see if that's a requirement. I haven't seen it in any of the charters that I've looked at. Being a resident is a requirement, but being a citizen of the country, I don't know. I'll have to do some research.
Don't you have to be able to vote in order to be.
No, that's a question that's being challenged now around the country. We've had all weekend in the news, the Kansas students who are 2 17-year-olds who are running for governor, and they can't vote, but they're running because there's a loophole in the law that doesn't say I can't run without being of legal age. And then I did find a couple challenges, and the challenges arose because city or county or municipal were not clear on being citizens. And I just think if we're pledging to the flag, if we're following our Constitution, it's very important to have someone who is sitting up here who says, I support those values, I'm a citizen. And again, for me, it's not about being naturalized or going through the process, but it is someone who has done that. So just to protect our city in a future lawsuit, I'd love to see that stated in the language.
Or
Could
say
you-
eligible to vote. Because eligible to vote means you're a citizen and over the age and 18
That
years
really
old.
does cover
Well,
that
that's true.
loophole.
Yeah.
So Ms. Sycom, would you do that? Would you research that and
Sure.
And
we
just,
all agree with that?
if I may just add, in the first one, in section 101 purpose, it says in accordance with the Constitution and the laws of Florida. So we may already find it covered in there that an elected official may have to be a citizen, so
And I
we
think-
just need to look and see if it's delineated in the laws of the state of Florida.
And I think
also.
at the state level it is, but then because of home rule, which we all want to protect, it hasn't been delineated as such.
Okay, so you'll research that?
Excuse me. Councilmember Donahue, we have a request from the sound booth. They're not hearing your microphone.
Sorry.
Thank
Pardon
you.
me.
Okay, put it in a nutshell, the main purpose of this section is to now allow the mayor to be elected by the citizens, but we would only have 5 total members, including the mayor, and the mayor would be able to vote. That's everything put in a nutshell.
Is it
Okay.
It's somewhere else that it says that, correct? It says that in more than one place?
Well, yeah, this is just setting up the structure of the council, the first section.
Okay.
That's to set up the structure.
Right.
But I'm just telling you, the reason we change the structure is to accomplish that part. All right, section 202. We added the newly elected members of city council shall be sworn in and take office on the second regularly scheduled city council meeting after certification of election results. And then council members shall serve no more than 2 consecutive 4-year terms and may not hold office again for a period of 2 years. And we struck out and shall not seek reelection for a period of 2 years. And the reason we did that is because the way it read before, after, no one could even get out and campaign, because they would have to campaign prior to the election. So what we did is we changed it so they could campaign before the 2 years are up.
Councilman Boss.
And I get the reason for that, and I completely agree with it. My only concern is sometimes it says 1 year, and election day may not always fall within that 365 days of a year.
Right.
You might have it fall 363 days or 362 days between that and the last election. So is that gonna go ahead and,
So should the wording be
well,
one
I
election
know, I guess
cycle
it would
out?
be all right, because technically you wouldn't be sworn in until after,
Yeah.
you wouldn't be certified and sworn in until after the election, so.
Right, yeah.
I just wanna, I know we're trying to correct, I don't wanna get caught up in minutia of a day, but I think since you wouldn't be sworn in, it wouldn't impact it, you would give you that extra week or so.
Good question.
Any other comments on that? Okay, then on the 204, interim vacancies, we just changed a couple of words. Instead of "the," for the beginning of the sentence, we added "an office or city council shall become vacant," blah, blah, blah. And then also, in the same section, it says we had secret ballots. Select by using secret ballots. You can't do that. So we're using written ballots instead of secret ballots, which makes us legal. Okay. Page 3, section 208. The council shall act by ordinance, resolution, or motion. And we had 4, now we changed that to 3 members shall constitute a quorum. And they struck out, well, I won't go to strikeout because that'll get you all confused. But anyway, so it'd be 3 members shall constitute a quorum. Said, and they, before it had, except during an emergency session, when 3 council members shall constitute a quorum. But now it's just 3 anytime will constitute a quorum.
Councilman Ross.
Yeah, I had a question about this, but I had the same question before it was amended, so help me out here. I've read this and read this and read this, and maybe I'm misreading it, and you can help me. isn't this redundant? It says the same exact thing. It says 3 members shall constitute a quorum, and then it goes on about an emergency ordinance shall be exact, and it's the exact same thing.
Yeah.
So why do we need the language about an emergency ordinance if it's the exact same? Is there, but it did that before too, and I never could figure that
Yeah.
out, why it said that, because it's the same exact,
You're right, it is saying the same thing.
yeah.
But-
Is there a reason why it has to say that, or?
Can I interject here? There's actually specific verbiage in our ordinances that addresses the emergency ordinances, and I think they put it in here to address that particular situation.
Yeah, but it still takes 3 council members to vote on something, whether it's regular business or an emergency. So do we have to delineate the difference between the two? There is no difference.
Only because there's a difference delineated in the ordinance, in our ordinance to begin with. So I think for the purpose of consistency, you're talking about an ordinance versus an emergency ordinance. I mean,
Okay. All right, same page number 3, section 209, the veto, that's out because if the mayor could vote, we obviously can't have her veto too, or him. So that whole veto paragraph is out.
Councilman Rice.
I apologize to keep interrupting,
That's
but
all right.
obviously this is important. In the old language, in addition to there being language that talked about the veto, which I understand now is moot under
Right.
this new structure, but it also addressed the contingency if the mayor refused to sign an ordinance. It took effect without the mayor's signature under certain conditions. Under the proposed language, it just says the mayor who shall sign the ordinance whereupon it shall become law. There's no language that says what happens if there's a ordinance that we pass, that passes the council, that the mayor just is morally opposed to and will not sign. What happens?
I think she'd be compelled to sign it.
Or the vice
The
mayor
mayor
sign
signed,
it?
the mayor voted one way or the other.
Well, but the
But even if
mayor
she voted
voted on the
against it-
losing.
Yeah.
I mean, it's-
If the body still voted for it, I think he would.
But
You
there-
would have, the mayor would have to sign it. If the council passed it, if the majority of the council passed it,
how can you write a law that requires the mayor to sign something?
Well, the mayor's required to sign.
There,
What if there's something that the mayor finds morally objectionable and refuses to sign? What happens then?
then if they're not going to perform that duty, then it would have to go to the vice mayor.
And if the vice mayor refused to sign it?
Then I'd have to do some research.
Then we would wonder how
So-
it passed.
But there's no provision in here for it to become law without the mayor's signature. And I mean, that's not such a far-fetched scenario. Suppose that something, we've had some pretty not heated, but some pretty divisive discussions about medical marijuana or other issues, and I could see something, if I were mayor, that would come before me and say, I respect the wish of the council, but I'm not signing this. It goes against my religion, or it goes against my whatever.
Or are you just saying then in that last sentence in that was struck out could just be added to that, basically? Where the last sentence says, any ordinance which shall not be returned to the council at the next regular meeting of the council after its passage shall become a law as if signed by the mayor.
I think
That's
some
true.
version of that would
If that would go
suffice.
in there after that, this way, if the mayor or vice mayor didn't do what they were obligated to do, then you have issues about recalls
Right.
and everything else, about failing to perform your duty, but I get, you could have a moral objection to signing something that may come
Sure.
before us, I can't imagine it, but
well, what
it could,
this-
but
what this says here is, I think you read it, Bob, but before going into effect, the ordinances passed by the council shall be submitted to the mayor, or in her absence, the vice mayor, who shall sign the ordinance whereupon it will become law. It doesn't say could, it says should, or could. It says shall sign the ordinance. So to me, that means that if the council passes it, the mayor has to sign it.
Okay.
I don't have any objection to. I don't have any objection to the word shall. It says what your duties are. If you don't want to take that duty and responsibility, don't run for mayor. So the fact is, if you're ordered to do it, you may know that thing's objectionable. I mean, I signed things here that I wasn't happy with signing
Sure.
regarding some organizations, but you signed them when I had to sit in there. and It's the way the cookie crumbles.
Yeah,
If
and
it
I
says shall,
do,
you shall.
and I do like the line that Councilman Boss pointed out, the last line of the paragraph that's been struck out. And if for any reason the mayor or the vice mayor refuses, or for whatever reason are not available to sign, it will go into effect as if it had been signed.
Can't hurt.
Would you like me to add that under the new section 209 at the end?
I think as Councilman
Well,
Ross brought that up.
I would like
yeah,
some
I think
language in
that-
there,
yeah.
but I'm just one person. I mean, if everybody else is thinking that I'm thinking things, then I'll,
I'm fine with it being added. It just covers the
Fine with it
bases.
being
Mm-hmm.
I would rather say too much than leave something vague. And I agree with you. I think that if that still makes sense to put it below.
So leave that last sentence in there on, the
Any
section.
ordinance which shall not be returned to the council at the next regular meeting of the council after its passage shall become a law as if signed by mayor or vice mayor. And I see Mr. Schisler is
No
attempt.
provision to bring it back to council.
yeah, we'd have to,
That never occurred.
we would have to change that language somewhat, because that's
Yeah.
referring to
Right.
the veto, that no
It has to be
longer.
along
Okay.
the lines of, if, it would just automatically become law, it'd be
Yeah,
no requirement.
if signature doesn't happen,
Exactly.
it will become law. Yeah.
Exactly.
Okay. So do you want to add that sentence, the last sentence then, or no? The last sentence.
There seems to be
any
consensus.
ordinance.
Something like that,
Yeah.
Something like
Yeah.
that. I think you need, I do agree, you need to clean it up because
Yeah.
it's referring to something that no longer exists.
Okay.
And then the people can take it up with the person who didn't sign it when they were commanded to sign it by the charter.
Exactly.
And on page 4, section 212, recording and authentication, every ordinance upon becoming law shall be, before it said recorded in a book kept by the city clerk, and we just said shall be maintained by the city clerk. Just the wording change. Any problem with that?
No. I
Okay.
think that's your last change, right?
What?
No.
Oh, no, we got,
I'm missing a page. Okay, sorry.
all right, section 302, election. We added to that, the mayor shall serve no more than 2 consecutive 4-year terms and may not hold office again for a period of 2 years. The newly elected mayor shall be sworn in and take office on the second regularly scheduled city council meeting, same as the regular council. It's just that we had it separate for the mayor, since now that she'll be voting member. Any problem with that? Okay. Section 303, we just changed the first sentence where it says he, we changed it to or she. And we deleted, as you could see, however he shall have, speaking of the mayor, however he shall have no regularly assigned duties except to break any tie vote by the city council. The mayor shall have no vote. The vice mayor who shall act as mayor and assume those duties during the mayor's absence or disability shall be elected by the city council in a manner determined by the city rules or of order and procedure. The vice mayor shall be counted in the determination of a quorum of city council and shall discharge the duties of the city council member. That's out, all that is out. And we added, the mayor shall be counted for determining a quorum, have a voice in the vote in the proceedings of the city council, but shall have no veto power. He or she may use the title mayor in any case which the execution or written legal instruments or other necessity arise when the general laws of the state so require. But this shall not be considered as conferring upon the mayor the administrative or judicial functions of a mayor under the general laws of the state except such administrative functions as are not consistent with the charter when directed by the city council.
I don't know what that means.
Well, the mayor shall be counted for determining a quorum,
Oh, no, I get the first part. It's
Okay.
that last
have a voice and
long
vote in the
sentence about
proceedings.
conferring upon the mayor under the general laws of the state, except such administrative functions as are not consistent with this charter when directed by the city council. What would that be?
I don't know. I-
Mr. Schisler?
Well, she may have something, because she was involved in this aspect of it. And
I-
let me take a stab at this.
I think what this is proposing to convey is that the mayor of the city of Temple Terrace will not have the powers and duties of a strong mayor as it exists, say, in the city of Tampa, okay? And that's the mayor, the administrative or judicial functions of a mayor under the general laws of the state.
Excellent.
That's
And
a
that's it.
strong
We are,
mayor form
we
of-
are a
so-
mayor council form of
And that was my
government.
big concern, and the reason I was not in agreement with some of the changes, because I thought it still blurred that role of mayor a little bit and confused the public. They always look to the mayor in a city manager form to have more authority and more responsibilities than they actually do, because they see that at the city of Tampa, they see that in other large cities and other strong mayor forms. So I was hoping to avoid that confusion.
Well, should we,
If I may, just to talk a little bit about the genesis of this whole subject matter. Part of the reason for the charter review was, again, to cut down the size of the council and give a mayoral vote, if you will. And we talked long and hard about this and came up with several different scenarios, one with just 5 council members. Okay, so what happens? Somebody's got to be a mayor, somebody's got to play mayor. What's going to happen? How are we going to delineate that? Well, I'll do it this year, now you're an election. Well, what if they don't want to do it? Okay, and the more we talked, we deliberated over this for almost a month, I guess, and back and forth. And, we talked to others. Whoa, don't take away our mayor. We need, the Temple Terrace historically has always had a mayor, or for recent memories had a mayor. And it's how strong that person is has always been irrelevant, because they had no vote. They could offer their opinions, but, several mayors, or former mayors and current mayors exist in that. So we said, well, what about 4 council members and a voting mayor? Still gives the electorate the opportunity to elect a mayor, no more voting rights, no more power, but you still need that person who's willing to come out and say, I'm the mayor of Temple Terrace, and I want to go do this, and I'm going to take care of that. And I believe, and I may be wrong, this is just something I thought about later on, I believe there's some emergency issues from the state that you were talking about earlier, Charles, where the mayor has to do something in the event of martial law or something of that nature. And I can't remember the specifics about it. But that was the basis for this. 4 council members, 1 mayor, and then the people vote for the mayor. And this is something that I have yet to find anybody outside that has said, no, I don't want a mayor. They like the mayor concept, and this is why we did it this way. So the mayor has separate duties. The mayor still signs the ordinances. The mayor still is the outside representative, if you will, to a lot of things for the city in official capacity. And we segregated it because of these extra duties. And I think that there was some legalese involved with this to make sure that, they knew they were counted in the quorum because they never were in the past. And just to say, specify this in better detail, the administrative functions are not consistent with the charter, et cetera, et cetera, et cetera. So that's the genesis of how we came to them. Because it's really not addressed anywhere else in the charter. It's 4 council members and the mayor. This is how we got to where we are now. And this just better delineates it. Plus, it gives the level for the vice, the status, if you will, of the vice mayor upon election by the council.
And I appreciate the work of
But we
the
didn't-
committee on this, because truly, we are city manager council form of government, and it's very important to delineate that We are overseers, we are not day-to-day administrators of the city. And that's an important conversation, if there are citizens who don't understand it, to say, we have someone who day-to-day is at the helm, running the city. We are an oversight body. So I appreciate the work of the committee on sculpting this language the way you have. Thank you.
Yeah, our intent was not to allow the mayor to be a strong mayor as in Tampa or the other places.
Very good. Councilman Ross.
I have a question, though. I understand the intent. I understand all of that, and I've read this over and over again. But there's one part of this, let me draw your attention to this. There's one part of this that I think there's an extra word in here. I can't make this make sense. So look at this part. At the very end of section 303, the new part, the underlined part. I won't start at the beginning of the sentence because it's long. But the second part of the sentence that is talking about how we don't have a strong mayor system, and I understand that. The second half of the sentence, beginning with, "But this shall not be considered as conferring upon the mayor the administrative or judicial functions of a mayor under the general laws of the state." I understand all that, except such administrative functions as are not consistent with this charter when directed by the city council. I can't get that to make sense to
It's-
me.
I think there's a typo there. It's supposed to be inconsistent, not consistent. It's supposed to say, "Accept such administrative functions as are not inconsistent with this charter when directed by city
Well,
council."
that would make the sentence make sense.
That's what I've been trying to say.
All right, give me that again. So are not,
Inconsistent?
are inconsistent?
That makes it make a whole lot more sense. Thank you.
Thank you, Councilman Ross.
I
Okay.
think Mrs. Donahue had something.
Well, I still question whether or not we really spell out that we are going to maintain the city manager, city council form of government. Did I miss it somewhere in the charter?
Yes, it's
Actual
still in the
words?
beginning. It's in the,
It actually says,
Yes.
okay, all right, if that's the case,
Yeah.
okay,
We
then,
just started later.
okay, I see it,
Okay.
okay. It wasn't in red. I think I
All
probably
right.
read all the reds. Yeah, okay.
304, section 304, vice mayor. A vice mayor who shall act as mayor and assume those duties during the mayor's absence or disability shall be elected by the city council in a manner consistent with the city council rules of order and procedure. That's
Right.
pretty clear. All right, ordinance number 506 is out, apparently legally, for a legal reason. Ratified 6-5, that's all out. Let's see, pardon?
Page 5.
It was on page 5.
Right above section 3.04 or 3.05.
See, it says ordinance number 506. You see
It's
that?
not in red.
But it's struck out. Okay, section 401, office created. We added, well, actually, we didn't add. It just says that the city manager shall be chosen by the council. And this is, we discussed this at length. But the city manager shall be chosen by the council solely on the basis of executive and administrative qualifications with special reference to actual experience or knowledge of the duties of the office of the city manager. At the time of appointment, the city manager shall not be a resident, shall not need be a resident of the city or state, but within 6 months after becoming city manager, he shall become a resident of the city unless otherwise provided by ordinance. So we discussed the situation of the city manager being a resident of the city.
That
And
didn't change, though.
That
that's-
didn't change, so we decided not to change it, because we want to have that, gives the council the flexibility. So if by chance you got a candidate that lives in the city, but he's not near as qualified as somebody that lives out of the city, that you would have the flexibility to hire the most qualified rather than the one that lives in the city. So you have that flexibility. So we kept that the same. And we did discuss that at length.
We have a question from Councilman Boss.
Just one comment, really, since we've done it and corrected it in a bunch of the other things. When it gets to the last line, where it says, but within 6 months after becoming city manager, comma, it says he shall become a resident, and all the other ones we've corrected, he to
Okay, well,
he or she.
he or she.
So
We could-
just
yeah.
a Scrivener's
point.
kind of thing, but
Okay,
I didn't see it in any other part there, but since we've been correcting them.
you're right. Okay.
It's easy to do, trust me.
Section 602. Pardon?
Yeah. It's just the word her.
I changed that. I changed it or not? Oh, yeah, okay. City manager or his/her. So we have to change, we changed that too. His or her. Okay. 602, submission of budget no less than 45 days before the expiration of the fiscal year. The city manager shall present to the city council a budget for the ensuing fiscal year. The form and content of said budget shall be as provided. We had by ordinance, but it was recommended that we change that to resolution. And Gil, why don't you explain the difference between
Okay.
ordinance and resolution?
According to Mark at that point in time, the resolution and ordinance effectively accomplished this is the same thing in the approval process of the budget. The ordinance requires form filing with the state under two separate statutes. I want to say 161 and statute 200, I may be wrong on that, but they're separate. And if you do by ordinance, you have to file under both of them. If you do by resolution, you only have to file under one of them. And it becomes very problematic, and errors are very easy to occur. And if there is an error, everything's got to be refiled, and it's got to be brought back in. It's a substance over form issue. Substance of the budget doesn't change whatsoever. Transparency to the council and to the public, no change whatsoever. It's just the final format of the adoption of the budget. There's still two public hearings, there's still all the budget meetings and so forth, and if I'm wrong on that, please, anybody stop me. But that was something that we dug very deeply into with Mark at that point in time, is to make sure that there was still total transparency to everybody and all parties concerned, and it was just a format issue at the end under the resolution was easier, quicker, cleaner, less risk of having to come back, and if you remember, they had to come back for the third time this past year because there was a filing error done which required more cost in newspaper reporting.
Well, it's a legal ad that you'd have to do for an ordinance that you wouldn't have to do for the resolution. But the budget also requires a separate legal ad for the finance part of it, so it's kind of redundant
Yeah.
for the legal ad.
So that was the purpose of that, is to just streamline that down and make it easier for everybody and less risk of any issues.
Thanks, Gil.
I do have a question. You
Okay.
didn't change everything to resolution, though?
No, just that.
Just,
Just that.
just the budget? Okay.
Councilman Ross.
I'm not sure who to address this to, so I guess probably the city attorney, but when I read this, I wondered what I mean, I know the difference between ordinance and resolution, but I wondered what the significance was of this, but can't we pass a resolution in one vote? In an ordinance, we have to have public hearings, first reading and a second reading?
Yes.
So my concern when I read this, and if I'm wrong, I'll withdraw my concern, but my concern is that we can pass the budget on a resolution in one meeting, just pass it. Whereas an ordinance requires two publicly noticed readings of the ordinance and provides more opportunity for public input. Isn't that, I mean, it's not like there isn't any opportunity with a resolution, but it's substantially less, is it not?
I understood it to be the same as far as notification and,
It still
Yeah.
has to be notified. You still have to
But-
publish notice, there still has to be a public hearing,
There does.
so, yes.
Chapter 200.065 is the state law that cities and counties have to follow in order to adopt their budgets. It calls for adopting, you remember going through this, I'm sure, adopting a tentative millage. You're essentially adopting a tentative budget, and you're having input for that, you're having meetings for that, you're having the public come and talk to you about that, and then you go through the process again, 30 days later, I guess it is, to adopt your final budget. So the state prescribed process for adoption of the budget is very extensive and involves a lot of public input. So I don't think you're giving anything away by taking out that ordinance requirement. Because by adopting your budget by resolution, you're following that state law.
I'm okay with it as long as we're not limiting the public's ability to comment on the budget. We're
No.
spending their money. I want to make sure that they have every opportunity to comment.
yeah, we understood that from, at that time, I think it was Connolly that brought that up. And he said there would actually be no change in terms of
Okay.
transparency.
Well, that's my only concern. So
Yeah.
if it's,
Okay, and 603, same thing, changing from ordinance to resolution on a sentence that says, "The budget shall be adopted in the form of a resolution and shall constitute an appropriation for the amount specified," and so on. So that part didn't change, it just changed from ordinance to resolution. Section 701, elections. All elections shall be conducted as provided by law and in accordance with we had chapter 7 before, and now apparently that's been changed to chapter 2. So it's just a change in the chapter number. Everything else is the same on page 7. On page 8, 704, section 704, it said, actually, 704, we're just changing and adding for facsimile signatures and are adding or electronic signatures. So it's just, in the same way in the next paragraph, where it says, "Except with regard to the passage of ordinance, city council may authorize the use of facsimile signatures," and we added or electronic. Section 700, and also we added 705, a year after the expiration of his or her term of office. That means, that's in the paragraph that says, "No elected official of the city shall hold compensated appointed city office or employment until 1 year after the expiration of his or her term." 706, with the exception of emergency ordinances or ordinances, and we added "and resolutions relating to the budget, capital improvements, appropriations of money, levy of taxes, or salary of city officers and employees, the reconsideration of any adopted ordinance by petition, signed and registered electors, equal in the number to and not less than 10% of the registered electors registered to vote at the last election of mayor or city council. The form of such position shall be provided for under, it had the provisions relating to recall or elected officers. Now we're adding section 100.361 to Florida statutes. If the council fails to adopt the ordinance so proposed, or to repeal the ordinance reconsidered, the ordinance shall be approved or rejected at the next election, excuse me, or the mayor or city council, if time permits, at the special election scheduled for this purpose. So we're taking out the part that says the provisions relating to recall or elected officers, and we're adding section 100.361. If you would like, would you explain what that section is, so they'll know? Yeah,
The Florida statute addresses the procedures to be used there, so essentially what we're doing is just incorporating it and adopting those procedures rather than coming up with our own. So, and if you want me to tell you what they all are, I don't know that right here. I don't have a copy of it in
All
front
right.
of me.
okay, any questions on that? Okay, next,
Well, I just have a quick question
Yeah,
before,
Bob.
before we move on to the next section. When we get to section 709 regarding boards, it said the city council shall appoint boards and members thereto as it deems desirable. The terms, duties, and responsibility of the members of all boards shall be determined by ordinance. That, I just want clarification. Does that mean when we appoint someone to a board, we have to do an ordinance for it? Or does that mean when we set up the boards, we create an ordinance that creates the boards and the duties of the people?
I'm sorry, which number are you looking at?
709.
709?
said boards.
I just want clarification. That's what it seems. The latter, when you set up and create a board, you do it by ordinance. Okay, great.
Okay,
So, and the question is that according to the charter, you have to do this by ordinance in order to set up.
Right, if we set up a board, we would have to do an ordinance, have its 2 hearings, and set up a board, like the Riverwatch Task Force, or, well, I'm not that sure if that's a board, but like the Code Enforcement Board, so, which has already been done, so if we created a new board, we'd have to do it by ordinance. I was just, one clarification, one that meant when we elected someone, it had to be an ordinance, because we certainly aren't doing that, that's all.
So,
That was just clarification.
yes.
Thank you.
okay. And the last thing we added was section 7.17. Charter review process shall be conducted at least every 10 years. This way we'll have something in our charter that specifies a review, which we haven't really had, so that's it.
Are there any additional comments or questions from council? Councilman Ross, then Councilman Pagorley. Councilman Ross.
I have it's a question, I guess, for everybody for discussion. First of all, let me say, I am in favor of giving the mayor a vote, if we can figure out a way to do that, that doesn't have a lot of collateral damage. But here's my scenario that I want to talk about. If a sitting council member resigns or dies or for whatever reason does not finish their term, there's language in here that allows us to short-term appoint basically a replacement for that city council member until the next election. So we could replace a city council member pretty quickly. There's a provision in here that allows that. If, however, the mayor, as we've recently experienced, doesn't finish his or her term, there's no comparable language in here that allows that. I don't know if we can even do that, but we can be, and as we all well know, ask Mr. Boss, we can be without a mayor for, this can take 6 or 8 months. It took a long time to get a new mayor. So here's what I want to think about here a little bit is suppose that we have this new makeup where we have 4 council members and a voting mayor, which sounds great. I mean, I'm okay with that on the surface, but what if the mayor doesn't finish their term? And suppose, just hypothetically, I know this could never happen, but suppose that we have a divided council like we often do, and now we have 4 people, right? I could see this council not being able to conduct business, to get anything done for 6 months or more until we get another mayor. So my question is twofold for the city attorney, and you may not, I don't expect you to have the answer at the tip of your finger if you don't, but I have 2 questions. One is there any possibility under state law of adding in here so that if the mayor position becomes vacant, the governor can appoint a mayor like they do the sheriff if the sheriff doesn't finish their term or something like that, so that we can continue to operate until the next election? Or is it legal for us to add language in here for us to appoint a mayor like we can do if it's a city council member that becomes vacant? So my concern is if this goes on the ballot and it's adopted, again, I'm all in favor of giving the mayor a vote, but we just went through 6 months or more of having no mayor. In this model, we would have been getting nothing done for 6 months. And that's my concern.
The selection of your vice mayor is a very important selection because that is the person who would automatically, logically become the mayor. Then you would have to follow the procedures to find a replacement for that person, not as vice mayor, but you'd have to replace that missing council member. So your vice mayor moves up to mayor, and then you replace your council member, and then you would have to have an election, as you did the first time, to pick a new vice mayor.
Okay. So we would be okay because the vice mayor would vacate the city council spot and then we could replace that person.
Correct.
Okay.
Now, would that apply, for example, it says here that if a city council member, first of all, the mayor will appoint, according to this, the mayor shall appoint a 5-member citizen committee. The citizen committee shall be comprised of registered electors, blah, blah, blah. Within 30 days, this is if a council member is gone for whatever reason, that they appoint, that this committee then would interview whatever candidates there are to replace that council member, and they could elect one and to be an interim council member.
Well,
So would that apply here?
You would follow your procedure. You would follow, if you're just missing a council member, you would follow your procedures here. If you're missing a mayor, the vice mayor moves up to
Right.
become the mayor. And then that person, as the mayor, would have to follow these procedures
Yeah.
to replace themselves.
But if he moves from council member to mayor, does that have an open seat for city council? Where then they could go ahead, the citizen committee could appoint somebody to fill that spot in the interim until there's an election.
And is that
So you would
appointment,
sti-
is that appointment just until the mayor gets elected
The appoint,
for the council member?
If,
and that's,
That appears to be what it would indicate in section 3.06 on interim vacancy, unless we were going to shift or change that, that it would be an interim vacancy.
here's my follow-up question I think we're trying to get at. So the scenario that you gave, Pam, the vice mayor moves up to mayor, vacating their city council seat. We appoint an interim city council member. A new mayor is elected. The vice mayor then moves back down to their council seat. What happens to the person who was appointed? They hit the street?
They're just interim.
no, they're just filling the spot temporarily.
yeah, he's interim, that's
So,
all.
Yeah. Could they run?
Sure.
can they run?
They could run.
But the vice mayor is not in any jeopardy of losing their seat. When the new mayor comes in, they get to go back to their city council seat to fill their
Right.
Correct,
rest of their term.
correct.
And the temporary appointee, the interim person, is just gone. They're no longer,
Exactly.
okay.
I think that would need to be spelled out. I think that need to be spelled out in the charter regarding that secession type of
Yeah.
scenario, to make it just clear that everyone knows what would happen.
Well, there's a lot of moving parts to that.
Yes.
Yeah, especially what would happen to that person.
So do you want to add that to the charter? Is that what you're recommending?
I would
That
think,
language?
I would think something like that that has so much fluidity to it that, you know, obviously it's not a problem if it's only the mayor should die or leave or whatever. That creates the problem. And then if you're gonna have that transition temporarily to an election, It's just gotta be spelled out. This is what happens. They take over as mayor. Then the council, then the mayor, then he or she appoints a committee to go ahead and select an interim council member for that time frame. And as we can see, there's always delays with the, coordinate things with the clerk of the elections office and everything else. So, as long as it's spelled out cleanly as to what would occur. I get Andy's point, though, you could be in gridlock
I mean,
forever.
the committee, we can meet again, the committee can
Yeah, we could do that.
discuss some language to add to that, to make sure that the interim person doesn't hang on to their chair and doesn't leave when they're supposed to, if that seems to be the concern. So, we can work on that.
Okay.
Well, I think
I don't think it's as
okay
much
with
a
you, Gloria?
concern as, you know, we
Is
had
that
a
all right
couple
with
of
all
years
of you?
ago.
We just-
No, I'm sort of kidding, but I can see where that might happen,
Okay, well, we could do that.
so.
Well, I
had-
think there's two concerns. One is that the vice mayor that becomes mayor doesn't lose both his seats because he became mayor for somebody that, you know, left or no longer around. That he gets to go back to that council member position, and that the interim understands that if they want to run for council, they can, or mayor, they can, but they're an interim, and that means a temporary seat.
Okay,
So, I have some questions about everything but that.
Well, I think you,
Yeah,
you were still on
we-
this, though.
we had a candidate who was not elected mayor, and his thinking was that if something happened to the mayor, he would step in because he was the second, also ran.
Yeah.
And we, it clearly
That's
indicated.
not how it works.
But it clearly indicated in the council, according to us, that was not, this has probably been, Joe, how many years ago? 10 years ago? But I am in
Oh,
agreement
okay.
that the more you say here, the clearer this becomes.
okay.
So when you leave it out, you leave it open to, you know,
All right,
guess, and,
okay.
yeah.
We'll have a meeting and try to clarify all that.
Sorry, guys, you thought you were finished.
No, that's a good point. Because you want to make it as clear as you can, so there'll be no questions about it.
Right.
Councilman Pagoralik.
Thank you. I apologize for that, for missing the front end of this workshop, but in my review of all the changes, a lot of this looks to be cleanup and trying to get us in lockstep with requirements of the state of Florida. Is that not so?
Well, that and also whatever
So-
changes we might recommend.
Right, so whatever changes you might recommend. So I guess my question to our council, to Pam, is if this goes to referendum, how is that going to be handled? Is every paragraph change going to be a separate vote? Is all the maintenance items lumped into one, check this box if you're in favor of it? And secondly, if it doesn't pass, what happens? Because we've got to do it anyway, because we've got to be legal. So I guess the first question is, does the maintenance items and the changes required by the state to make us in lockstep with the state requirements, does that piece need to go to vote as well?
anything that's substantive needs to go to vote. If there are things where we've maybe done some gender-neutral things and we've corrected some typographical errors, there can be, it still needs to go to referendum, but it can be lumped together in one, giving the council the authority to make all those minor changes by ordinance. So each little change from an A to an and doesn't need to be a separate referendum item.
Because, I mean, I can see a situation where if we have to itemize all this, 3 of them pass and 4 of them don't, but we got to do the other 4 anyway because 3 affects the other 4. So what I would like to see is, since you're going back to the meeting anyway, is some sort of breakdown on changing the makeup of the council and giving the mayor a vote. Obviously, that needs to go to a vote, okay? These items, we know, don't have to because they're just maintenance items, dotting the i's, crossing the t's. These, we're not sure about. Because what I don't want to see happen, and Joe and the committee, you know this as well as I do, is that we end up with a, a referendum that's 6 miles long, and everybody gets confused, and everything gets not passed, or everything gets passed because nobody understood what the heck they were voting on. So I'd like to see what we're getting into, so that we can talk about it and maybe consolidate and make this something that makes sense for people to vote on.
Well, as soon as we get this the last changes made, I can start grouping them to
Okay.
see what we can put together and how few we can turn this into.
And, you know, I want to remind everybody that this all started by the idea of giving the mayor a vote. And I don't want that idea to suffer, because we've got a gazillion other maintenance items that everybody's got to vote on too, and it either passes or fails, not on its own merits, but because people get fed up with all the other minutia they got to vote on anyway. Because, if this referendum is too long, we're all going to suffer as a result of it.
It can only be 75 words.
No, that's not true. If you put something together, it's 75 words. If a government puts something together, it can be as long as it needs to be.
If I might,
All right,
I was looking at some other cities and what they've done as far as their referendums, and just talking about things that may be clerical issues. And one of them that I ran across was, this was the separate referendum item, and it was titled Granting Authority to Make Clerical Changes to Charter by Resolution. And it says, the city commission will be authorized to pass a resolution to make clerical changes to the charter in order to correct language that has become obsolete or inappropriate or does not conform to commonly accepted usage. This amendment applies only to minor corrections that will not alter the meaning of the charter. It will not apply to policy or other substantive changes which will require approval by the voters. And then it was just vote yes to approve or no against. So that was how they lumped some of their issues
Okay.
together.
But I'd like to see that breakdown before we start making decisions
Okay.
on this.
Okay.
Councilman Boss.
I thought when we were looking at, later during our meeting, when we look at the timeline of everything, I thought that's what we're gonna kind of look at, the setup, getting the wording kind of straight that the committee is recommending, and going through little things here that we kind of noticed and had questions about. And then, after we've set up the process where we have the public hearings and public comment on them, then we would go down to the point of splitting everything up and breaking it down into the separate ordinances that had to go out for the referendum, and that's where we'd have our discussion on that. And I agree with you, they need to be broken up, otherwise it's.
I'd rather know that sooner rather than later.
But I think that goes through the process of the public comment hearings first, where they have to give their input on everything, and then we know what ordinances to pass and how to direct staff to determine the ordinances and how they should be broken down. And I think we're the ones that make the determination on how the ordinance should be drawn up and broken down to put on the referendum. So it'd be us, and I agree, you don't want to have a significant issue like the change in the form of government, which, again, I disagree with, but I'm very glad the committee got together and made their recommendations to us. Again, I disagree with it, but it's, for the citizens to vote on and for everyone to come back to us with their recommendations based on the review. And then for the citizens to make an ultimate decision, but they should be split up. And that ordinance or addition to there may make that correction where, you might find things later on down the line, like we found today where we missed a his or her. We don't have to go through
Yeah.
referendums to correct those every single time we find something.
Right.
But,
Okay.
so, I think that would be later on down the line, when we create the ordinances, that we break them up into how it's done.
Councilman Shalera.
Thank you, Madam Mayor. And Joe and your team, thank you all for coming forward and putting this together. I would, first be interested in knowing, as discussed just now, how the structure would come forward. Because if you put 10 items on a referendum, you could pretty much crash the plane before it takes off. You're gonna confuse, us as council people, Ms. Donnie, you brought up a good point where it said the administrative functions of the judicial functions, people are gonna get lost. And they're not gonna have an attorney and a body of folks to talk to and say, can you please explain this to me? It's gonna be too confusing and too complicated. It would be helpful to know if this goes to referendum, this is the way it's gonna look. there's gonna be 1 or 2 items, and the rest is housekeeping, or is there gonna be 7 or 8 items? And as Mr. Boss and others have alluded to, whenever there's something that sounds confusing, or we have to guess, please put an example below it. Because Ted Todd wrote the ordinance saying you cannot, when you were here too, Joe, you cannot run for office for 2 years. Well, Mark Conley came in and said, oh, no. That means you can't even run during that 2-year period. But the intent was that you had to be out of office for 2 years. You could run within that 2-year period. But it got misinterpreted. And yes, we could have gone and got another opinion, so we didn't want to go there. But I think the more you can elaborate on something when there's confusion, the better off we'll be. And I'll give you an example of one of those items. You guys talked about on 3.04, I'm sorry, on 2.02 and 3.02. It says, the red line that you put in there, where it says the mayor shall serve no more than 2, and this is also the same in 2.02 and 3.02. One talks about mayor, one talks about council. It says the mayor shall serve no more than 2 consecutive 4-year terms and may not hold office again for a period of 2 years. What office may not they hold again? Can they not run for Senate? Can they not run for city council? It's not clear, because we've been through this, and we need to identify that. It's good to put that in there, but, we're all perfect on the sideline, but once we've experienced something, we need to make sure we can document that. It could simply say, may not hold mayor office again for a period of 2 years. And the one for council should say, may not hold, Mr. Mayor and Mr. Fronte and myself, we were on the council and ran for mayor. I actually had a term in between, but he didn't. He went from a council member to the mayor's seat. And then somebody can sit there and say, oh, you've held the seat for more than 2 years. So I'm just trying to create any kind of, because we went through that recently with the term, you have to be out of office for 2 years. And most of us interpreted that as you have to be out of office for 2 years. Mark Conley came in and said, no, you can't run within that 2-year period. So just having lived it and done it, I would like it to be, clear to that point. But I think the most important thing is any examples that can provide is fantastic. Less is better. The paragraph that Ms. Donahue alluded to that seemed very long. It's great if you sit there and you really focus and analyze it, but a lot of voters won't do that. How it's going to be structured, how it's going to come forward, if it's going to be, this is going to be housekeeping, how it's going to look like, how it's going to be presented to the voters. Because if we have, my opinion at least, is if you have a more, a handful of items up there, it's going to be challenging. If it's 1 or 2 items, the city or the folks can explain clearly, these are the items that are up. But if you put a whole bunch of stuff up there, it's going to be, we just have to be, think it out before we did it. And I'll give you an example. Years ago, the city put on, do you want a tax increase on a referendum? And at the same time, they said, does the area behind Victorian Village want to become part of Temple Terrace? That was a disaster. You want me to become part of your city and you're increasing my taxes on the other side. It should have been in two separate referendums, do one and then do the other. But, if I was a resident coming in, so you're gonna raise my taxes, you want me to come to your city? And they both failed. So, if we do something and we spend lots of time, energy, and effort on it, I want to be able to make sure that it has every opportunity to take off. That's the only thing I want to add. But you guys did a great job, and you've dissected this, and I agree with you that every so many years that this needs to be looked at, because ordinances change, statute changes, it keeps everything fresh and in front of us. But I would like to see how it's going to be brought before us and how it's going to be presented to the voters, how many items are going to be there.
Thank you, Councilman Shalera. We do want to be intentional, and we want to be very clear and transparent.
Absolutely.
And I will echo Councilman Shalera. Thank you, Chairman Affronti, and your entire team that worked on this, and we really appreciate your service.
All right, well, we'll schedule another meeting, and I think you have everything down. So we'll be back to you then. We'll just set up another workshop with you when we have everything put
And
together.
and we have one more question, Chairman Affronti. Councilman Ross.
This is just for our attorney. The paragraph that you just read from another city, that was good. What was crossing my mind when I was listening to that is perhaps language that also includes legal requirements. And what I'm thinking of is if the voters don't understand the reduction of two-year residency to a one-year, if they don't know that we have to legally do that, there's no way that's gonna pass. So if you had on the referendum that allows us to do by resolution to change things that are legally required, that would take care of that, because as soon as people see we're gonna lower the requirement of residency from 2 years to one, that they're never, I just don't believe the voters in Temple Terrace are gonna go for that. But there's case law that says we have to do that. So if you could maybe include that.
All right. Yeah, if there's some way of separating what must be done when we go out with the referendum, so they have really no choice. They gotta vote for that, or we'd be illegal. And the ones that we suggest be changed, so, but we'll work on it. Okay, so,
Thank
anything
you,
else?
Chairman. Are there any
Well,
other
thank you.
questions or comments from the
I
council?
just have one. I know that there is, there's legislation right now pending that will change our elections. And I suppose if that happens, I just want to make sure that if there's something that changes, of course, we'll know that because they're in session right now and they're voting on that right now. It automatically will change some of these things, and we don't have a choice there. We
Yeah,
will
I
have
don't-
to.
I don't know what those changes.
Oh, they're complicated. It's mainly about runoffs, but it could change, and I'm sure
Okay.
between,
All right.
between city clerk and city attorney, that, I'm just saying, that may be another area that has to change, and we don't have a choice on it
Okay.
if it passes. It
All
looks
right.
like it's going to pass.
Okay. Okay, well, thank you so much. Thanks very much for your time.
Thank you, Chairman Affronti.
Thank you.
And we will stand recessed until the 6 o'clock